So much for technicalities. So let me just, before I hand over to Professor O'Neill, give you a very brief recap of the first two lectures. On the first day, Professor O'Neill started with a condensed historical overview over how during the 20th century, the concept of rights started to replace the older concept of duties as the fundamental notion of ethics. And this took place in philosophy as well as in public discourse and the political domain. Professor O'Neill then also pointed out three potential problems that come with this shift from duties to rights. One concerning the question of who ought to decide that, who ought to see to it that rights are being followed. The second having to do with the fact that for every right there is a corresponding duty, but the opposite is not true. So focusing on rights might impoverish our picture of ethics. And then the third problem arising because rights are almost always qualified. And so we have to adjudicate between them when they conflict. That was the first lecture. In the second lecture yesterday, Professor O'Neill focused on one specific field where these problems come to the fore, which is the ethics of communication. She pointed out the many ethical as well as epistemic norms that are relevant in this domain. For example, accuracy or honesty or something like refraining from defamation. And then she argued that those human rights that do actually pertain to communication, namely freedom of expression, rights to privacy, are insufficient to guarantee upholding of this variety of norms that should govern communication. And so we could kind of see how focusing exclusively on rights actually impoverishes the ethical domain of communication. Tonight, we are hearing the final lecture. It is titled Duties and Rights, Would More Be Better? I would suggest that now the commentators as well as the organizers, we all turn off our videos and so that people can focus on Honora's talk without distractions. And with that, I'm very honored and pleased to hand over to, for this year's final lecture, Munich lecture in ethics. Honora, please.
Thank you, Marius. Well, that was a very accurate summary of what I said. I feel I could hand over to you. But that question, would more be better, it seems to me is a perennial question in discussions of rights. When things don't look quite satisfactory, we're inclined to say, well, after all, these are just international instruments. Maybe they could be improved. Maybe we could add some rights, subtract some rights, both add and subtract. And it's very popular to think that if there's something wrong, it is simply that there weren't enough rights, not that a focus on rights alone might have been problematic. And there are several questions that would then arise. Would adding to the list of rights be likely to improve matters? How would it do so? Would it serve us better? Would subtracting from the list do better? Would that create problems? Can there be a definitive list of rights? And would that list, if it exists, include all, let alone only, the Universal Declaration of Rights, or all or only the European Convention rights? Now, I'm going to suggest that problematic though this is essentially the problem of justification. The problem of judgment in deploying appeals to rights is actually more difficult to resolve. And that is because there are so many different ways in which rights may need to be qualified. They require both interpretation and mutual qualification. And qualification is not just by other rights, it is also by those perfect duties, I'll come back to those, that do not have counterpart rights. So appeals to human rights, as I see it, however we list them, however detailed the specification, however heartfelt our endorsement of them, don't offer a complete account of ethical or political requirements. and action always has to be shaped by a wider range of technical, ethical, and epistemic norms and standards on which interpretation and practical judgment rely. Rights matter. I'm in no way denying that, but they cannot offer us a complete view of the requirements of justice, let alone of the wider ethical concerns that we have. So, on the whole, I've said rather little about justification in these lectures, although it is, of course, the top theme in many contemporary discussions of human rights. The most enduring and best known fault line in current debates now, and I think for some decades, has been the disagreement about whether rights are best seen as moral or political. Those who see them as moral argue that they should be justified by considerations that are anchored not in the decisions or requirements of international bodies, however august, but in deeper, more abstract moral arguments. That's the reason why human rights are seen as universal rather than as the political and civil rights of some jurisdiction or set of jurisdictions. An attraction of this line of thought, that's a deep attraction if it can be made to work, is it will offer reasons for anyone, indeed for everyone, to take those human rights for which sound arguments are provided seriously. Of course, the list can be supported by robust justifications. The list that can be so supported may not coincide with any of the canonical declarations. On the other hand, those who see human rights as political also have a strong case. They hold that they have authority because they have been endorsed and instituted, and to some extent enforced, by states and international bodies. On this view, rights require institutional backing and are to be accepted because they have been agreed, instituted, and ratified by those states and by international agreement. This approach sees it as feasible to provide a definitive list of human rights at a given time, for those, for example, those listed in the Universal Declaration or the European Convention, but it doesn't assume that that list should be universally acknowledged and leaves it open the possibility that the list might be changed. This contrasts with claims that human rights have moral authority, which may be heavily disputed, but on the whole is seen as precluding, or certainly as being less open, to the view that they could be revised. Well, both positions, as you all will know, face well-known difficulties. If the justification offered is moral, some widely accepted human rights are going to have to be set aside because no sound argument for them has ever been given. Notoriously, that post-war gem, the right to holidays with pay, strikes many of us as culturally narrow, an artifact perhaps of mid-20th century industrial cultures, which ignores the reality of the lives of subsistence farmers, of women whose work is in the home, and I suppose of also to some extent of those who work in the gig economy. And some rights claims, for which reasonably robust arguments can be offered, may in fact have little practical impact because they lack institutional standing and backing, and because state and international organizations have not, or not entirely, included them in the agreed lists. And if we conclude that human rights need both moral and political backing, then some supposed rights that have been included in conventional lists may simply lack sufficient justification, and others for which no moral support can be found, no moral reasoning, will perhaps have no place in the conventional lists. These tensions, I think, can't be ironed out merely by listing rights that have been promulgated, accepted, and ratified by the states party to international agreements at a particular date. Claims that certain supposed rights are bogus, even if some states and international bodies have endorsed them, or that further rights should be recognized, even if some states and international bodies are very skeptical and refuse to endorse them, both make sense, although both sorts of claims make serious difficulties. If the justification of rights were solely and entirely positive, the first concern would have to be to look at the rights that have been actually recognized, agreed, endorsed by the appropriate authorities, whichever they are taken to be. Moreover, those authorities could then add new rights to the tally, and they've quite often done so in the past. That's what all those additional protocols to fundamental human rights declarations are about. And presumably those authorities can remove supposed rights from the canon if they decide to do so. And there are costs to being political as well as advantages, aren't there? And probably the best examples of demotion or removal of standards that are widely seen as human rights would point not to international organizations, but to the action of various illiberal regimes that have opposed some or restricted some rights, including some quite widely accepted rights that are included in the canonical declarations and conventions. For example, they may take a restricted view of freedom of expression or freedom of movement within one's own state, claiming that these are excessive or bogus rights, or simply that they're not rights at all. So declarations and conventions, such as those that we've mostly attend to, may include what one might think of as false positives. There have been plenty of regimes that dispute specific rights, either for all their inhabitants or for members of certain social groups, and there are plenty of disputes about which to recognize, in the course of which some supposed rights get discarded and some that were previously counted as human rights were promoted. I think the culture wars of our own day have generated additional examples of disputed claims about rights. In many cases, these appear to arise from disagreements whether rights should be premised on statements about the identity of right holders or on statements about the senses of identity of right holders. Older views took it that rights were premised on the objective identity of right holders. For example, they were humans, they were men, they were women, they were children. More recently, there have been arguments for focusing on claims about senses of identity of right holders, thereby enabling individuals to lay claim to rights that fit the specific ways in which they see, understand, and present themselves. Culture wars apart, the list of human rights has, of course, varied considerably, not just across our own times, but for centuries. And I think there's nothing particularly surprising in this variation across time. Parallel examples of changes, expansion, contraction of lists of norms and standards that are taken seriously have often varied across time. For example, it's not about rights, but not very closely. Consider codes of medical ethics. They too have classical origins. The Hippocratic Oath. They too were elaborated in later professional codes for doctors. They too have been modified or extended and rejected or undermined. For example, the Nazi rewriting of the doctor's oath discarded or ignored parts of the previously accepted norms for medical practice and research. And the older standards for medical research on human subjects were later reaffirmed and restored in the aftermath of the Second World War. You see the parallel with the trajectory of the human rights movement in the form of the Nuremberg Code. And the Nuremberg Code has, in the post-war period, I think from 1964 onwards, been hugely expanded and codified in successive versions of the Declaration of Helsinki. I think about 13 versions, and it reached the point where I suspect that nobody who is asked to consent to the terms of the Declaration of Helsinki can get her or his mind around it. So discussions of human rights and medical ethics have in many ways taken parallel paths from ancient origins through legal and professional codification to disruption in the World War II period and restoration, combined with ever more intensive codification in the post-war era. This process of selective augmentation and rejection, coupled with relentless codification, continues. past disputes have objected to some formulations of rights, for example, because they didn't fully or explicitly recognize the equality of women or certain ethnic groups. So it's asserted they did not extend equal rights to all, and that was often plausible. Today, rights to same-sex marriage are variously advocated, ignored, or dismissed by some as bogus rights that reflect Western or liberal or woke excesses. Identity politics has, in short, become a source of many disagreements about rights. However, these disputes do not, in my view, get to the most difficult issues, which reflect the fact that conflicts between rights are frequent, and it's not clear how they're to be resolved, neither adding to the list of recognized rights, nor subtracting items from the list, nor adjusting rights in other ways, nor proposing or undermining justifications of selected or proposed rights, offers a simple way of addressing the reality of the difficulty of judging what rights require. So I want to turn now to the practical problems, and I'm going to argue that they are in the end, although perhaps not intellectually more difficult than questions about justification, nevertheless fiendishly difficult. Many of the practical problems raised by human rights don't arise because there are disputes about which rights there are or how they are to be justified. People quite often take answers to those questions for granted. My personal view is that there's a lot to be dealt with there, and that justification of standards that explicitly claim authority that stretches beyond political boundaries cannot be anchored solely in appeals to the decisions, interests, or commitments of those speaking for or representing bounded states and their inhabitants, or by appeals to agreements in global fora of such representatives. For that reason, I take it that even the most august human rights documents may simply lack adequate justification. But I also do not underestimate the difficulty of supporting a view of human rights, or even of a selection of human rights that requires moral justification. Nor do I underestimate the difficulty of relying solely on moral justification and ignoring the importance of providing an account of relevant state action and enforcement. I see problems, in short, in every direction nearly. However, today I want to set these demanding and very high stakes arguments aside. And I'm going to do this not because I doubt whether they matter, but because even if one or other position could be established to everyone's satisfaction, and that's pretty unlikely, by the way, even if they could be established, this would leave central questions unresolved, since neither position, neither type of position, if you wish, addresses the practical difficulties of judging what human rights require in a wide range of situations. And these practical difficulties are considerable. So let me try to list some of the systematic practical problems. Again, I don't dispute the fact that securing recognition and respect for human rights standards raises other difficulties and other difficult practical problems. But let me focus on some of those that I think are pervasive, but too often neglected. I argued in the first two lectures that human rights, however they might be justified or justified up to a point, can't stand alone for at least three distinct but connected reasons. The first reason, and it has been repeatedly discussed, is that human rights have got to have counterpart duties, but the identity of the necessary duty bearers for some human rights is not specified or not adequately specified within the human rights charters and declarations, and it's not obvious even if you stand back from the charters and declarations. And so one needs institutional action to identify or to establish the duty bearers. The rights for which identification of duty bearers raises no problems include liberty rights, where the counterpart duties not to infringe or obstruct other people's liberties must in principle fall on everyone. Of course, that's true, but it's in a way quite misleading, because in any particular context, the burden of respecting a liberty right is likely to fall much more heavily on some than on others. The second reason for thinking that human rights can't stand alone is that in many situations they make conflicting demands, making it necessary to qualify some rights in order to respect the demands of others. It follows that human rights do not set unconditional requirements, and that respect for human rights will frequently underdetermine what is required in a particular case, or will offer an incomplete view of what is and what is not problematic. The third reason that I noted for thinking that human rights can't stand alone is that some of the considerations which the canonical human rights documents treat as legitimate grounds for qualifying specific rights have nothing to do with requirements to protect other rights. Rather, they permit, and they often require, the qualification of human rights in order to satisfy objectives and standards that are not required by rights. To remind you on this point, the permissible qualifications of the right to privacy that are listed in the Universal Declaration's version of that right include matters that are, quote, necessary in a democratic society, in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, and for the protection of health or morals. Well, these are important reasons for qualifying rights to privacy, but they don't refer to any human rights, or not directly. Moreover, they offer quite an incomplete list of the considerations which require the qualification of claims about human rights. The fact that human rights claims must sometimes be qualified doesn't, of course, license ignoring them or overriding them for just any reason whatsoever. In particular, when there is or is likely to be a conflict between a human right claim and a discretionary action, the discretionary action must give way. I might be correct in thinking that by stealing all the property of some billionaire, if I could then end hunger for thousands by securing their rights to social security and supporting their economic, social, and cultural rights. But, as the same charter asserts, there's also a right not to be arbitrarily deprived of one's property. So my intention for the proceeds of my theft would not be a sufficient reason for me to seize and redistribute assets like some contemporary Robin Hood. If I aim to support others' rights to social security or to a decent standard of living or to a basic income, a permissible approach would need to support action to extend taxation and the redistributive use of the receipts. Doing so would be compatible with both rights, would not be arbitrary. Underlying point that I'm illustrating is that with this example is simply that generosity, evidently an imperfect duty, is discretionary, and so it doesn't provide a sufficient basis for qualifying, let alone for infringing or restricting human rights. On the other hand, where a conflict between a human rights claim and a non-discretionary duty is at issue, that is a duty that without a counterpart's human right, matters look quite different. In the first lecture, I pointed out that the classical account of perfect duties covers many duties without counterpart rights that are not seen as discretionary. And in the second, I pointed out how many of the duties that bear on communication are perfect duties without counterpart rights. For example, moral duties such as honesty, civility, fairness, epistemic duties such as aiming for accuracy, offering sound evidence, refraining from exaggeration. These are not seen as discretionary duties to be satisfied on occasions when an agent chooses to do so, but ignored when she prefers to ignore them, but as perfect duties. They are perfect duties without counterpart rights. Where human rights claims clash with perfect duties that have no counterpart rights, one duty will have to be qualified by the other, and sometimes both will have to be qualified to some degree. These considerations, I suggest, show that respecting and securing human rights must take account not only of other human rights, but of further standards. And in a way, that's the point of the title of these lectures, suggesting that human rights are not enough. They're not self-sufficient. They're not self-contained. Human rights are indeterminate, but they're not unconditional. And that makes judgment of their demands in particular situations complex in many cases and contested. Many discussions of human rights, in my view, say little or too little, if they say anything, about the importance of this difficulty of practical judgment in the realization and respect and realizing and respecting rights. And this seems to be an important omission. So I'm going to try to say a bit. But that is a bit about practical judgment and human rights. Practical judgment can, of course, be more or less complex, often depending on the ways in which various requirements that an agent seeks to satisfy might clash, with the result that some requirements have to be set aside or set aside in part in order to satisfy others. In the simpler cases, one of the standards that clash in a particular case might be discretionary and another not discretionary. And in this, the discretionary standard can simply be set aside. Well, so far, so unproblematic. But where more than one of the standards that clash is non-discretionary, the only way of proceeding is to qualify, or more bluntly, let us say, to overrule or relegate one standard or one aspect of the standard in favor of another. So unsurprisingly, if one starts out with a very large number of non-discretionary standards, qualification of great diversity and complexity may be needed, and so it is with human rights. Since human rights are numerous and complex, the burden of judgment needed for determining how each right may or must be qualified in particular cases is often very large and very demanding. Moreover, since human rights may also have to be qualified by other non-discretionary considerations, the burden can ramify. The problem is to grasp what makes qualification of one right by another acceptable. And I'm sorry, I'm not going to provide a neat and tidy answer to that one. To understand what makes dealing with potential conflicts, either between rights or between rights and other perfect duties, so demanding, it is, I think, useful to think about some of the basic differences between practical and theoretical judgment. Theoretical judgment is a matter of applying principles, concepts, rules, laws to actual cases. Two forms of theoretical judgment have often been distinguished, in particular in Immanuel Kant's late writings. He called them determinant and reflective judging, and I will use those terms. Determinant judging is used when we ask whether a particular case, some actual object, situation, action, person, whatever, is covered by some principle, concept, rule, or law. When making a determinant judgment, we ask questions like, is this bird a sparrow? Is this phrase a quotation from the Universal Declaration? Was that killing an accident? Here we are applying a concept or rule or law or principle to a particular case. Other type of theoretical judging is called reflective. Again, a particular case is given, but here it's uncertain which concept or rule or law or principle may be relevant. One has to hunt around for that. Reflective judging addresses questions such as, what sort of a bird is this? Which language is this passage written in? Was that action unlawful? Reflective judging is essential for many forms of activity and inquiry, and not only for those that we think of as centered on interpretation, though of course it is indispensable in all areas of life where interpretation matters. However, neither determinant nor reflective judgments are practical judgments. Practical judgments are different because they're forward-looking. Rather than applying standards to existing cases, they aim to shape the world in some very small respect. In practical judgment, the aim is to enact or realize a future state of affairs. so that it fits some concept, rule, or law. The task is not one of application, and in my view, the conventional assumption that practical judgment is what applied ethics is about is just incorrect. In fact, that phrase, applied ethics, is simply a misnomer. Practical judgment is not a matter of applying concepts or principles or rules or laws to actual cases, since the relevant cases do not yet exist. It's a matter of shaping some aspect of the future, as I said, in some small respect. To summarize, while theoretical judgment is a matter of applying rules or concepts to actual situations, practical judgment is used to enact or bring about cases or situations that meet certain requirements. A wide range of technical, ethical, and political judgments are used to bring about states of affairs that satisfy some or many principles or rules or concepts, some legal requirements, or indeed some human rights. This is central to practical judgment, as it seeks to shape action, including practical judgment, and that it seeks to enact human rights claims. So how should we think about this? One way, I think, of thinking about the indeterminacy of human rights claims might be to compare and contrast them with earlier attempts to give neat little lists of ethical requirements. Many of the best known lists from the distant past were much shorter than the contemporary human rights documents. Perhaps I think because printing was not available and other ways of communicating and memorizing had to be used. And other ways of communicating can be laborious. These lists were, of course, also lists of indeterminate standards whose enactment also required practical judgment and could also lead to dilemmas and conflicts. I've already mentioned the Ten Commandments, but there are many other venerable lists of ethical norms and standards that in their day had great influence and renown. We think, for example, of Plato's four cardinal virtues: prudence, justice, temperance, courage, to which Christian thinkers added the three theological virtues: faith, hope, and charity. And of course, there can be tension between the elements on these lists. Another classical example was given by the Roman jurist Ulpian, who offered a more compressed and abstract list summarizing the principles of law. And no doubt my Latin pronunciation is different from that most of you learned, but juris praeceptus sunt haec, honeste vivere, alterum non laedere, suum cuique tribuere. These are the principles of law. Live honorably, injure nobly, give each his own. Many other past cultures have set out quite elaborate lists of the most influential standards, norms, virtues, which can and often have been enacted in many ways. And the contemporary mania for codification has lengthened, strengthened, and elaborated the list of normative claims, including, of course, human rights claims, that are seen as relevant to many, or indeed to all, areas of human activity. And this growth has both disadvantages and costs. Adding to the lists of required standards, nevertheless, is often seen as useful, yet it's likely to compound rather than to resolve the difficulty of making practical judgments. As soon as there are more requirements to be satisfied, there's likely to be more potential for conflict between them. Whenever we seek to enact a very large number, of non-discretionary requirements, conflict is possible and practical judgment is needed to determine which requirements should be used to qualify which other requirements. Unsurprisingly then, practical judgments, including those that seek to address human rights rules or human rights standards, are likely to become harder because more is not, it might be better, but it's certainly not easier. Having more rights, more rules, more codes, more process may simply lead to more problems and make it harder to reach decisions. This suggests to me not merely that human rights are not enough, but having more human rights might be even more difficult, more problems to resolve. Multiplication of rights, in short, does not, in my view, offer a way of resolving the potential conflicts between rights. And even if we thought that the list of rights should be reduced rather than expanded, there would be problems still. Problems would remain. Appeals to rights, in short, don't by themselves show what should be done. They are not sufficient to guide action unambiguously. This is true, but I think there's also more to be said. The reason why human rights are not sufficient to guide action is, I think, that they, like other principles of action, are indeterminate, whereas the action that has to be taken will have to be determinate. In the end, it just has to be determinate. We need, I think, actually, I wonder whether that's true. I might think that certain actions can be left ambiguous. We'll have to discuss that more. We need, I think, to take seriously the reality that practical principles underdetermine practical judgment. In particular, we need to take seriously the reality that human rights principles, despite the ethical and political weight that is ascribed to them, often underdetermine what should be done. One way of looking at this would be to regard any available resolution of that underdetermination as adequate. This will not strike you as very impressive, but one could, for example, say, well, why not select the first option that occurs to you, or that occurs to the agent, or the easiest option, or the most convenient option, or the cheapest option? This would, so to speak, offer a decision procedure, but it would amount to seeing practical judgment simply as a matter of picking, of selecting one or another available action that satisfies at least some human rights standards. It would, in effect, view judgment as a matter of blind, unsupported, unreasoned choice, mere sheer picking. No distinction here is drawn between better or worse judgment, and none could be drawn, and the very notion of judgment would in effect be marginalized and made redundant. An alternative way of viewing matters would assign priority to some principles, for example, specifically to human rights principles, as the way to resolve indeterminacy. This would amount to assigning priority to certain principles as the ones to be respected, even if others were simply ignored, at least ignored in a particular case. However, the justification of prioritizing some and ignoring other principles of action, of prioritizing some and ignoring other human rights principles, is far from obvious. On the one hand, we can imagine assuming that rights could be ordered so that some took precedence over others. If they could be ranked so that precedence was unambiguous, it might perhaps be easier to see which determinate judgments should be reached. But doing so would in effect assume, or more likely impose, a determinate process for judging, in effect edging towards the idea that there might be an algorithm for practical judgment. But this, it seems to me, once again dispenses with, undermines the very idea of judgment. The basic context of practical judgment is that of facing a plurality of principles of norms that cannot all be satisfied in a given situation. Assuming that practical principles could be ranked in a particular order would resolve indeterminacy by assuming that they should be taken in this order or that order. And yet such a ranking would undermine the very assumption that each human right makes a serious and distinctive claim. Asserting the priority of a particular right, say of the right to freedom of expression or to freedom of movement, might indeed resolve some indeterminacy, but it wouldn't show why that particular ordering of principles resolves indeterminacy correctly, rather than being arbitrary. Once again, it seems the demands of judgment would be being trivialized rather than satisfied. But recognizing perfect duties other than those that are the counterparts of human rights can bear on judging what to do in a particular case. If we cannot have an algorithm for practical judgment, in effect, eliminate the need for judgment, then we can do no more than consider the case for giving priority to various ways of dealing with cases. Consider, for example, it's a very well-known example, but I'm not going to discuss any of its textual features. It's an example in one of Kant's late essays. The would-be murderer comes to your door looking for his victim. You are the householder, and you make it a principle not to tell lies. What should you do? And as soon as we try to imagine how to address this situation, and how would we address it if we really faced it, I think we will be aware that a huge number of circumstances could vary. The would-be murderer might be a threat to the householder as well, or to others. The intended victim might be a threat to the would-be murderer. Don't even know that. The intended victim might well be a threat to others. Everybody involved may be frightened or enraged, or richly deserve some form of hostile action. We don't know from the spare story we're told. Alternatively, everybody involved might have a number of good reasons for acting in various ways. I think we can see that there could be many different versions of encounters between householders and would-be murderers. The idea that one can exercise practical judgment by considering the case in the abstract is just misleading. This is not just a case in which truth-telling and injury to life and limb conflict. It's a case in which the underdetermination of action by principles can be made vivid. And that, I think, makes it actually typical of cases that have to, where difficult practical judgments have to be made. Such cases can't be resolved simply by asserting or giving priority to one consideration. Practical judgment isn't a matter of blind intuition or of naked preference. But nor can they be resolved by constructing complex processes for prioritizing considerations. There are, I think, no algorithms for practical judgment, and practical principles have neither a determinate order of priority nor determinate implications. Moreover, practical judgment is helped, not harmed, by considering a wide range of non-discretionary requirements, both those with and those without counterpart rights. This, I suggest, is why it makes sense, and indeed it is important, to speak of good judgment and poor judgment, which it wouldn't be if the only possibilities were either dogmatic appeals to intuition, I think this is right, or equally dogmatic attempts to devise algorithms for practical judging. These considerations suggest to me that the reasons why human rights are not enough are actually profound and ineliminable, and would apply to many other areas of normative, including ethical concern. The problem is not that the received lists of human rights are too long or too short, or that they wrongly include some bogus rights, or that they fail to include some rights that matter, although many lists are no doubt open to those charges. It is that an adequate account of practical reasoning must allow for the reality that practical judgment is neither a matter of blind intuition nor of complex calculation. Indeterminacy is ineliminable, and we must, use a colloquial phrase, seek to do our best, despite the fact that we have no way to identify or calculate the right answers. These conclusions suggest to me that we should treat even the most august lists of human rights with caution and reserve. Rights are not trumps. They are part of a complex process of practical reasoning that can identify important constraints, but often that is not enough to tell us what ought to be done. So I conclude, human rights are indeed not enough. Inventing or endorsing more human rights, expanding the canonical lists, would not be an improvement. Practical judgment about human rights requirements also needs to take account of other norms and standards without counterpart rights, and there's no way of insulating or separating justice from the rest of ethics. Thank you very much.
Thank you so much, Honora, for this incredibly, well, not just this talk, I guess for the whole series of incredibly wide-ranging and thought-provoking lectures. And we're now going to take a 5-minute break before Monika Betzler, the speaker of the Munich Center for Ethics, will take over. And then we will hear from our 3 distinguished commentators, Lara Valentini, Stefan Gosepat, and Jeremy Waldron, before Honora gets the opportunity to reply, and we shall end with a very short Q&A in the end. Okay, so we'll now just be gone for take a break, very quick break, and we'll be back in no time.
Commentators. As our program is dense tonight, I'll kindly ask our commentators to stick to their assigned 20 minutes. The distinguished commentators will present in alphabetical order because we need some order. So I take the liberty to give the word first to my colleague, Professor Gosepat, who holds the chair for practical philosophy at the Free University in Berlin. And then we turn to Laura Valentini and Jeremy Waldron. This will take about 60 minutes. And then we take again a very, very short break of a couple of minutes, and then give the word to Professor Neil again. So Stefan, the screen is yours.
Okay, thank you very much, Monika. Thanks for inviting me. It's an extreme honor and pleasure, actually, to comment on Honora O'Neill's challenging lectures. So thanks for the occasion. Let me start with a counter-narrative to the one Honora O'Neill provided in the first lecture. On December 10th, 1948, the Universal Declaration of Human Rights was promulgated by the newly founded United Nations. With this declaration, the ambitious experiment entered a critical phase. The idea of human rights, as it had been outlined in the 17th century natural law tradition and proclaimed in the 18th century Virginia Bill of Rights and the French Déclaration des droits de l'homme et du citoyen. So this idea of human rights was established as the standard of a globally binding moral order. In our contemporary era, human rights have become, despite all reservations about making this claim, a globally effective normative standard of humanity. Although they continue to be disregarded and violated in certain states at times, almost all individuals and states are prepared to accept human rights as a de facto moral standard, even if this acceptance is partly lip service. As regrettable as the violations of human rights are, we must not forget that there is hardly any government which, when accused of violating human rights, would defend itself by denying that such rights exist or by dismissing them as artifacts of Western imperialism and so on. If we first look at the development in a positive light, we see something quite astonishing. Human rights have become something historically unprecedented, a global, cross-cultural and transnational moral order, something, for example, the big world religions never accomplished. Honora O'Neill, as the great philosopher she truly is not blinded by such a superficial view of this successful rise of human rights. She is suspicious of the turn to rights in the last 2 centuries. I take it that with JFK, she would like to tell us, don't ask what rights can do for you, but ask what duties you have. More seriously, in particular, as you have heard today, she takes a closer and more critical look at human rights. She argues that human rights cannot stand alone for at least 3 distinct but connected reasons. Let me quickly repeat. First, human rights must have counterpart duties, but the identity of the necessary duty bearers for some human rights are not specified. Second, in many situations, human rights make conflicting demands, making it necessary to qualify some rights in order to respect the demands of others. And third, some of the considerations which the canonical human rights documents treat as legitimate grounds for qualifying specific rights have nothing to do with the requirement to protect other rights. I don't disagree with the Nora O'Neill diagnosis. Human rights cannot stand alone. But I don't really see the problem here. I take it that human rights should not stand alone, nor do they stand alone. On a not uncommon institutional approach to these matters of political morality, one which I share and try to sketch here, human rights are a necessary part of an institutional settlement of our common condition of politics. In the following, I will try to argue first that human rights are a morally required human institutional creation to solve certain problems of the human condition that moral duties and corresponding moral rights cannot solve alone. And second, given the institutional setup of which human rights are an essential part, there are, by the same token, further institutional features in the political and juridical human rights practice that make it possible to create or to identify relevant duty bearers, to deal with conflicting demands, and to balance human rights against institutional requirements that are there to enable and protect human rights in the first place. To begin, let's take a different look than Honora at the relation between purely moral duties and rights. Moral rights are not just the corresponding passive elements of moral obligations and cannot be reduced to the latter, even in a case where a relational obligation of Y corresponds to a moral right of X. For having a right is closely connected with self-respect. In order to clarify what it means to be a bearer of subjective human rights, compare a society containing only moral duties, consisting of special commands and prohibitions, with a society containing subjective human rights as well. That thought experiment by Bedau and Feinberg and others shows the importance of having rights. Instead of being just the recipients of duties, only with a right does a person have a basis for claiming respect for one's own will. Rights are justified claims of persons against others who disregard their interest. They are something with the help of which persons can enforce their justified claims. However, the idea of purely moral, that is pre-state, pre-positive, moral human rights, is no comfort for human beings if these rights are not institutionalized. Hannah Arendt points out the shortcoming of a purely moral conception of human rights as follows, quote, "As Burke has predicted, the conception of human rights did indeed break down at the very moment when they were the only remaining rights and people could no longer appeal to national guaranteed rights." Quote, end of quote. In the appeal to human dignity and human rights, out of basic human experience, humans proved to be naked, and it turned out, quote again, that the abstract nakedness of being nothing but human was their greatest danger, end of quote. Human rights thus must be codified if they are to be effectively safeguarded through the state's monopoly of force. It is for this reason that the tendency to become positivized is also inherent in moral human rights, or so the claim goes. This gives rise to the moral demand that all moral rights should be legally institutionalized as legal rights, so that violations can be sanctioned by state coercion. Human rights have then a built-in component which morally obligates us to make them concrete and legally institutionalized. Until this codification and interpretation is complete, moral rights remain unsaturated. On the other side, a purely juridical understanding of human rights does also lay itself open to criticism. For the legal conception of human rights finds itself confronted with another equally fundamental problem, namely that if human rights are to be understood as necessarily deriving from particular communities' legislative practice in order to be safeguarded as codified rights, and if political communities are structurally or territorially limited rather than global, this would seem to mean that according to the legal conception of human rights, such rights can only be achieve validity within the political community in question or out of contracts of these communities. This, however, would contradict their universal character. A further danger was made apparent by the Nazi regime's abandonment of all standards of civilized conduct. After all, if the nation state had acted until that time as the sole addressee of human rights, and because of its unique power of enforcement, as the guarantor of human rights under totalitarian rule, it would become the worst violator of those rights. The historical experience of the horrors of the 20th century was crucial to the formulation of the global human rights consensus that marks this phase. In the experience of and struggle against barbarism, a new understanding of human rights became established, one that differs in important respects from earlier forms. It is this understanding which is expressed in the Universal Declaration of Human Rights of 1948, namely the realization that it is not enough to place the basic and human rights of people under the sole guardianship of the relevant national public power. The state, which due to its powers of enforcement should in fact be the guarantor of human rights, is itself in need of supranational control in matters of pertaining to those rights. What we have here is a new way of thinking about legal human rights, one that has its origins in fear, but is still grounded in significant part in moral rights. Why? This brings me to the specific justification of human rights. Human rights hold by virtue of membership in the community of human beings, a membership of which there is no good reasons to exclude any. Borrowing again from Hannah Arendt, a famous slogan by her, one could say, what is fundamental is the right to have rights. In my understanding of this slogan, which is not Hannah Arendt's own, we humans have the moral duty to reciprocally and universally grant each other the status of free and equal holders of legal rights. The second human rights associated with this one is the right to justification, the right in a sense of any person to veto certain norms, actions or conditions in the event that he or she cannot be provided with appropriate reasons for them. Among free and equal people, we recognize that it is simply part of the condition of politics that we, as reasonable people, should not expect to agree either on what gives meaning to our lives or how we should live those lives, nor should we expect to agree on exactly what justice requires and what we owe to each other. This is the second issue that requires institutional settlement. Recall that the first issue was the codification and interpretation of rights as legal rights or positive law. Only once we settle our reasonable disagreement by way of legislation do we know what is to count as just among us. Indeed, this is the core point of positive rulemaking by public authorities. To reasonably settle contentious politics and contentious questions of what we owe to each other, what rights as free and equal persons we have, when all has been considered and weighted. If a core task of public institution is to set reasonable disagreement as to what counts as just among us, then the result of the settlement itself must be justifiable to everyone over whom the settlement claims authority. Thus, we ought to aim at a consensus on certain moral principles, basic ones, while realizing that we are at odds with one another as to their justification, and will likely remain so, given the importance of the justification to us as individuals. This suggests that we should abandon the traditional idea of seeking a single philosophical foundation of human rights as a basis for the ultimate moral and political authority. This much seems to have been understood already at the drafting of the Universal Declaration of Human Rights. Jacques Maritain, who led the philosophical committee on the drafting of the General Declaration of Human Rights, put it like this, quote, "Yes, we agree about the rights, but on condition no one asks us why," end of quote. Human rights, I claim accordingly, constitute moral claims of a particular kind because they are based on a global, minimal, and overlapping consensus of different reasonable conceptions of morality. It is not only with respect to their content and their form that human rights have the kind of singular status that may explain their extraordinary career, especially in the 20th century, but mainly with respect to their justification in an overlapping consensus. This sketch, and it obviously can't be more than just a sketch, of an integrated, more institutional view of human rights answers the three challenges posed by Honora. Let me explain in turn. At one, human rights must indeed have counterpart duties and their respective identifiable individual duty bearers. The difficulty lies in the identification of the persons who are concretely required. As should have become clear, it is the role of the human rights institutions to identify the necessary duty bearers for the relevant human rights. The question is how human rights institutions should identify, in a non-arbitrary way, the right responsible agents out of the large contingent of persons who, according to moral reasons, are able to meet their obligation and have the responsibility or duty to act accordingly. A morally justified distribution of duties is part of the social contract that constitutes legal human rights and the necessary institutional practice for their implementation, interpretation, and protection. The allocation of duties for the protection of human rights is thus the third issue that requires institutional settlement. In order to account for the individual distributive joint responsibility in initial randomly composed group, humanity, a responsibility which at the same time opens up the possibility of effectively putting an end to injustices without overburdening the individuals, it is necessary to institute a coordinated collective based on principles of fairness. We thus have a situation where a cooperative agent is created through a conscious social effort. In a first step, action, rights, and obligations are ascribed to the collective agent as such, humanity. In a second step, profits and losses, of course, metaphorically speaking, are individually allocated among the members according to their causal, moral, and functional responsibility, as well as according to criteria of effectiveness and personal bonds. It is here that different criteria can be combined and weighted against one another. Two. Of course, in many situations, human rights make conflicting demands, make it necessary to qualify some rights in order to respect the demands of others. It is mainly the role of courts and judges to balance human rights against each other, mainly with the help of proportionality test. This requires practical, legal, and moral judgment, as Honora O'Neill explained in this lecture. Without such judgment, no right or duty can be correctly applied. The necessity of judgment is not particular to rights. It is a ubiquitous condition of the possibility of correctly applying any rule at all. Once we have institutions and trained personnel in place, we hope that then the responsibility of who is to make judgments will be clearer, and hopefully their judgments will be better. Three, in courts, human rights are not only to be balanced against each other in case of conflicting rights, but also often qualified not to interfere with central elements that are themselves not human rights, as Honora O'Neill points out, such as the rule of law, democracy, national security, the prevention of disorder, and so forth. As I tried to show, the constitutional frame is a necessary means to institutionalize, codify, and interpret human rights. As such, the elements of the constitutional setup should be protected as necessary and valuable features of human rights practice. To conclude, human rights should be seen as an integrated coupling of moral universality, legal codification, and the creation of framework conditions that are required for those rights institutionalization. In this framework, human rights are in principle not indeterminate with regard to the corresponding duties and duty bearers. At least they can be made determinate. So far, this is my response to the three challenges that I took up from Honora O'Neill. My response, of course, did not touch on Honora's other challenge, that in our moral practice, duties, even perfect duties without corresponding rights, play an important role that cannot be accounted for in terms of rights alone. I leave this challenge for others. Thanks so much for your attention.
Thank you so much, Stefan, for your very interesting comments. Without much further ado, I pass the screen on to Laura Valentini, who just took up the chair for philosophy and political theory at LMU Munich. Laura, please.
Yes. So I have slides. Can you see the slides? Can someone give me some?
Yes.
Yes. Okay, great.
Yes.
Thank you. Everyone disappeared. I had no idea. Okay, thank you very much. So the title of my comment is Human Rights Are Not Enough, but for what? And so I'm going to start off with some preliminaries. And here I'm going to be briefly summarizing things that Honora has said and that actually Stefan also picked up on. So please forgive me for the repetition. I'll be quick. So Honora, in her very interesting lectures, puts forward what we could call the insufficiency thesis. Human rights are not enough. And as Stefan has already reminded us, this insufficiency thesis is based on three particular claims. One is that the idea of human rights, to some extent, makes us lose sight of agency. It's based on a recipient-oriented approach and obscures the existence or presence of important duties without counterpart rights, be they perfect or imperfect duties. A second ground for insufficiency is that human rights can actually come into conflict, but reference to human rights considerations would not allow us to solve these conflicts between human rights. So again, human rights are not enough. And finally, human rights can be permissibly infringed upon on grounds other than human rights themselves. So we need to appeal to other non-human rights ethical considerations here again. And so on these three grounds, Honora claims, human rights are not enough. And here, like Stefan said a few minutes ago, I actually don't disagree with the substance of Honora's insufficiency thesis. So I think the little three bullet points I have on the slide state something correct. What I have some concerns about is more the framing of the thesis. Honora doesn't actually, I think, explicitly say much what human rights are not enough for, but I think implicit in her discussion is the thought that they're not enough to furnish the entire ethical universe. I mean, we cannot just appeal to human rights in order to solve all problems within practical ethics, in order to know what we ought to do. We need other ethical notions, and on top of that, not just principles, including human rights principles, but also judgment. And somehow my initial reaction to this was, why should anyone want to saddle human rights with such a task? Why should we think that human rights should somehow furnish the entire ethical universe? You know, why not first ask, what are they enough for? So if we don't think that human rights can possibly have this ambition of telling us everything that needs to be said about ethics, well, maybe, you know, we can flip the question on the more positive side and ask, well, what could they be enough for? Is there something that they're good for? They can't do everything, but is there something that they're good for? And this is the question that I'm going to address in my comments. So I'm sort of flipping the problem on its head to some extent and looking at it from a slightly more positive perspective. And in so doing, I'm still gonna refer back to quite a few things that Honora said, both in these lectures and in her work over the years. So in order to address the question of what are human rights enough for, or what are they good for, we first need to get a clearer sense of what rights in general are, and then I'm going to zoom in on the notion of human rights more specifically. Okay, so what are rights? Rights are a particular class of ethical requirements characterized by a binary structure that involves a right holder on the one hand and a duty bearer on the other hand. And I should say that I mean, this is a very, very complex question. I can only sketch an answer to the question, but I hope that the sketch that I'm about to offer is in line with the picture of rights that Honora also had implicit in her discussion. I think it is, but she can tell me whether I'm wrong about this later on. So rights are a particular class of ethical requirements characterized by a binary structure involving a right holder and a duty bearer. The duty bearer has obligations to perform or refrain from performing certain actions, obviously, and the right holder has the standing to demand or claim and in principle to enforce the performance of those actions. And I mean, many familiar rights like the right to life, the right to food, etc., have this binary structure. To say that I have a right to life is to say that other people have duties to refrain from endangering my life, duties that I have the standing to claim or to demand. Similarly, right to food means that other agents have a set of obligations to provide me with secure access to food, and that I can demand that they perform those obligations, and depending on the circumstances, I may proportionately enforce those obligations or rely on third-party agents to do so. Now, you might wonder, look, rights and duties are quite tightly linked to each other. So what exactly is special about rights? Well, what is special about rights is precisely that because of their binary structure, they create special accountability relations between their holders and duty bearers. In the words of, or paraphrasing Joel Feinberg, when we have rights, when we are right holders, we can look others in the eye and demand the objects of our rights as our due. So, it may be the case that I have an obligation to donate some money to the beggar I walk by on the street, but the beggar doesn't have the standing to demand that donation from me. The money, so to say, is mine to give. I have an obligation perhaps to give it to the beggar, but the beggar doesn't have the standing to demand to claim that money as his own, while the shopkeeper from whom I'm buying a chocolate bar does have that standing to demand, does have that claim, because he has a right to payment. And that's a relevant ethical difference that marks out the special nature of rights as a particular type of ethical concern or ethical relation. And this already sort of tells us that implicitly rights cannot be enough because they're only a particular kind of ethical relation. They have a special structure that other ethical notions don't have. For instance, duties without counterpart rights, be they perfect duties or be they imperfect duties. So already by being clear about what we mean by a right, we can identify to some extent the fact that, or we find it transparent that rights cannot be everything because they're a particular type of ethical notion that has this specific kind of structure. But here we're interested not just in rights in general, but in a particular subclass of rights, namely human rights. And so now I'm going to turn to the question of, what is the function of human rights? What's the point of human rights? What are they good for? Of course, this is also a massive question in which there's a massive literature in philosophy as well as legal theory. And I would have no way in the world of covering that literature in the little time I have available. And so to start from somewhere, which might seem somewhat authoritative, I'm going to start off by picking out two quotations from some information materials that the UN provides about human rights. So there are web pages where the UN, tells interested visitors what are human rights, and that's the answer that the UN gives there. So these are not quotations from the Universal Declaration, but from these UN pages. I have the links if you like. I can share them later on. So first paragraph that I want to quote is that human rights are rights inherent to all human beings. They include the right to life and liberty, freedoms from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. Everyone is entitled to these rights without discrimination. First paragraph that one can find in these information materials. Immediately after that comes a second paragraph that says international human rights law specifically lays down the obligations of governments to act in certain ways or to refrain from certain acts in order to promote and protect human rights and fundamental freedoms of individuals or groups. And I found these two paragraphs particularly interesting because in a somewhat imprecise, informal ways, I think they capture two rather different ways of thinking about human rights, which in the philosophical literature have been dubbed the natural rights view on the one hand and the political view of human rights. And so I'm going to say a little bit about both and tell you which one I think is more promising in answer to the question, what are human rights for? So let me start off with the natural rights view, and I'm going to systematize it a little bit. So on this view, human rights are a special class of rights marked out by three main characteristics that echo that first passage from the UN. They are ethical standards that apply to human beings by nature alone. They protect humans' most important interests, such as life, liberty, freedom from torture, etc. And this was not explicit in that passage, but somewhat implicit in the claim to universality that human rights make, they're held against everyone else in the world. And that, I think, is why this view is sometimes called a natural rights view, precisely because, there are rights that we have against everyone just by virtue of our humanity, just like natural rights. They are sort of, at least in character, similar to the kinds of rights we could in principle have also, say, in a state of nature. Now, this particular view, and specifically the third dimension of the view, is problematic for a number of reasons, some of which have been very well pointed out by Onora herself. So here come a couple of concerns. So first of all, and this is something that Onora has written a lot and very powerfully about, human rights cannot plausibly be held against everyone else in the world. Think about standard human rights like the right to food or the right to education. And think about someone like me. It's just not true that everyone else in the world has duties to make sure that I am provided with access to a decent amount of food, nor does everyone else in the world have a duty that a duty to see to it that I have access to good education and so on and so forth. We need to specify duty bearers. Duty bearers cannot be sort of everywhere for most of these rights. And until we have specified duty bearers, we don't really have rights worth the name, as Onora points out. And then there's a second sense in which this natural rights view might not fully satisfy us. And that is that not all rights violations that involve our most important interests seem intuitively to count as human rights violations. So this is a point that has been made by Thomas Pogge, amongst others. We are unfortunately actually faced on a daily basis with news about private individuals murdering others or torturing others. And although we find these to be abhorrent moral wrongs as well as rights violations, we would not standardly conceive of them as human rights violations, or at least that's not the way in which they seem to be presented in public discourse. On the other hand, if the very same wrongs, torturing, murdering, and so on, were carried out by governments, by states, the language of human rights would be immediately triggered or activated, as well as a certain kind of international concern. So it seems like human rights potentially have a more political dimension rather than this more private dimension. And this leads me to sketch the second view on human rights, which is the political view. Now, on this view, human rights share quite a lot of features in common with what the natural rights view says, except for the third and final one. So there's still ethical standards that apply to human beings by nature alone. They are still ethical standards that protect humans' most important interests. And, however, and here's the important difference, they're held against our governments or states, and their violation triggers a particular kind of international concern. And so we might think, this view seems at least somewhat more plausible, especially as far as, the duty bearer side of things is concerned. Maybe it is, not as far-fetched to suggest that my government has obligations to see to it that I have adequate access to food and to a good education, for instance, on my daughter or whatever. Now, unfortunately, things are not as easy, again, for reasons that Honora has pointed out in work of hers. So here comes a concern. It's true that states often have the capacity to secure these rights for their citizens, but some such states or governments lack the capacity. So we can think of weak states, failed states, quasi-states, et cetera, et cetera. I mean, I'm not just talking about states with the capacity, but that ignore human rights, that don't care about human rights. That poses a sort of very important practical problem, but at least conceptually speaking, we have a duty bearer and we can point to a human rights violator. The problem is when capacity is missing, and if ought implies can, we cannot saddle these states with duties that they're not in a position to discharge. And so what do? Do we abandon the political view? Do we come to the conclusion that even on the political view, to some extent, human rights are not enough? Well, I think one thing we can do is to try and broaden the account of what qualifies as political, so having a somewhat revised version of the political view by considering why states are seen as privileged agents. And this is going to be the last part of my contribution this evening. So why do we tend to think of states as privileged duty bearers when it comes to human rights obligations? I think that there are two interconnected reasons for this. So one is their sheer capacity to secure human rights. So typically, not always, for the reasons just mentioned a moment ago, states are powerful actors which exercise de facto authority over their citizenry, and it's this power and authority that gives them the ability to secure human rights. But there's also something more normative that I think picks out states as privileged agents. That is, they are entrusted with a background obligation to protect and safeguard their citizens from various threats. And I think that is why certain rights violations on the part of states appear to be morally distinctive. I'm now going to make an analogy that is a little bit of a stretch, but just to give you a sense of, what I'm getting at. So anyone who mistreats a child, of course, violates important rights of the child and behaves massively wrongly. But if a parent who is entrusted with a special authority and power over the child for the protection of the child does that, it looks like we are facing a distinctive wrong. A wrong that is in some respects qualitatively different from the wrong that occurs when the exact same neglect or mistreatment occurs at the hand of some third-party stranger. And although clearly we cannot compare citizens and states to children and parents, I think that the special authority relation that exists between them partly explains why there is something distinctively wrong when a state either neglects its citizenry while it could provide for them, or actively undermines some of their fundamental rights. And the power that states possess cannot be justified unless states also perform this protective function vis-a-vis their citizens. So that's the way in which the capacity and special normative relation conditions are tied together. And so if the reason why states matter as privileged bearers of duties in relation to human rights is they have capacity and a special normative relation, then we may ask ourselves, are there around in the world other entities with comparable capacities, at least in some areas, which therefore may also be tasked with performing these protective functions and whose capacities, whose powers could not be justified unless they also perform these functions. And people in the human rights literature have actually advanced some possible candidates for some agents. So transnational corporations could be an example. And in fact, there's at least one paper, maybe I've missed others, in which Honora gestures at this possibility. At least in that paper, she didn't sort of fully endorse it or explore it, but she gestures at this possibility. Other organizations and so on that have this political nature and capacity to them, although of course not paralleling the state, you know, we don't have a world state as yet. And even if those organizations were not enough, the ones that exist, human rights can still give us reasons to bring them into existence. So here I think of a parallelism, and this is going to be the last point that I make, between this way of thinking about human rights and the Kant-inspired way of thinking about the right to freedom. So, you know, Kant says, in the state of nature, we cannot fully have a secure right to freedom, or a right to freedom with a capital R. In order to have that, we need to leave, we have a duty to leave the state of nature and create an authoritative agent, a civil condition in the form of the state. And I think something similar can be said in relation to human rights. So if agents with the capacity to secure them are missing, then human beings, other states, and so on have an obligation to leave these patches of, so to say, state of nature and create the capacity, the agential capacity that is necessary in order to fulfill human rights, and in fact, in order to make human rights a proper reality, because as we've seen, without counterpart duties, there aren't really human rights in the first place. Okay, so to conclude, human rights are not enough to furnish the entire ethical universe. On this, I agree with Honora. They do, however, I have suggested on the more positive side, play an important distincting function within that universe. So I've tried to suggest what they're good for. That is, they place constraints of a certain binary nature, binary structure on the conduct of powerful political actors. And they also explain why such actors may sometimes have to be brought into existence when they are missing. And now, of course, you know, it only remains for me to ask Honora, what do you think? Thank you.
Thank you so much, Laura, for these rich comments. Again, without further ado, I pass on to Jeremy Waldron, who is university professor at NYU Law School.
Thank you, Monica. You can hear me?
Yes.
Yeah, so it's an honor to be invited to contribute to this discussion and to have listened to Baroness O'Neill's fine lectures. Let me begin by saying I want to applaud what Honora said in the first lecture about the importance of not neglecting discretionary duties or imperfect duties and duties of diffuse scope, such as duties of civility and honesty affecting communication. She developed this in the second lecture as well. I think these are very important points, and she's right that they have been wrongly neglected. I'm not sure I would blame this on the human rights movement. None of the documents we've been talking about, the UDHR, the ECHR, comes close to claiming or could possibly be read as claiming that human rights are sufficient, all you need for a complete morality or even a complete political morality. I agree with Stefan and Laura on this. All of these charters suppose that governments have and follow other legitimate and necessary policy objectives. Law and order, economic stability, foreign policy objectives of one sort or another, which are not mentioned in these covenants. A human rights covenant is not a complete political agenda. As innumerable commentators have insisted, human rights are best understood as a set of minimal requirements, not the whole of morality. They are put forward as constraints on the pursuit of other policies. So it's not a valid criticism of them that they make this claim to be the be-all and end-all. They make no such claim at all, never have. They simply don't. Maybe if we looked at specifically ethical theories that claim to be right-based, and I mentioned several times John Mackey's discussion in a 1978 article, Can There Be a Right-Based Moral Theory? You might find a more strongly sufficientarian position, but since we haven't talked about that in these lectures, I really don't want to go into that in detail. Mostly in these comments, I want to concentrate, like my two fellow commentators, on the concerns voiced throughout Honora's lectures about the failure to specify duties when we specify rights, and about the question of the conflict of rights, the bitter reality that rights may and often do conflict with one another. She's right to point both these questions are tremendously important, and it's important that we think clearly about what they involve. So let's begin by focusing on the specification of duties. Honora said if rights are to be claimed, the counterpart duties must be held by competent duty bearers, and duty bearers must be identifiable by those who claim to seek their rights, who seek to claim their rights. She worries that prioritizing a focus on rights doesn't offer a clear way of identifying who holds the counterpart duties. In certain cases, it's hard to identify the relevant duty bearers. It's not obvious who they are, and so on. Now, the first thing to say about this is that in evaluating this alleged difficulty, we ought to be careful with that treacherous philosopher's formula. It is not clear who the duty bearers are, or it's not obvious. The phrase "it is not clear" seems to imply that unless the answer would leap off the page of the convention or declaration with Cartesian clarity and immediate distinctness, then anything that is said doesn't count. But rights are for thoughtful people, and those who evaluate charters of rights must be prepared to study and do some hard thinking on the matter. The question, who are supposed to be the duty bearers, is undoubtedly an important one, but I wonder if Professor O'Neill has not exaggerated the failure of the human rights idea in this regard. For example, in modern human rights documents, the International Covenant on Civil and Political Rights, for example, and that's a good one to focus on because it is international law, it's a treaty, it's not like the UDHR, which is just a declaration. Rights are listed in the ICCPR, but often duties are listed as well. The ICCPR contains a considerable number of articles which explicitly indicate duties which are said to be held by states parties to the convention. Article 1.3, Article 2, sub-articles 1 through 3, Article 3, Article 4.3. State parties must do this, state parties must do that. There is also a large number of provisions where it's implicit, but obviously implicit, that the duties in question fall upon states. For example, rights relating to due process, or rights relating to the treatment of prisoners, and so on, rights relating to the legal system, rights that require the legal system to have certain institutions and safeguards. Here, the relevant duties are obviously upon legislators, constitution framers, judges, those who implement the laws that they enact and administer. And that's in addition to the rights that Honora rightly mentioned, whose corresponding duties seem to fall on everyone, like the right not to be tortured or the right not to be enslaved. So there are plenty of duty bearers already assigned, explicitly or implicitly, in these documents. Now, the complaint that duty bearers for rights are not obviously assigned perhaps makes more sense with regard to the second of the great covenants, the ICESCR, the International Covenant on Economic, Social, and Cultural Rights. For like the Declaration's social and economic provisions, that covenant does seem to specify rights in terms of states of affairs or conditions of recipients rather than duties. For example, it emphasizes the right to safe and healthy working conditions, a right to an adequate standard of living, a right to free primary education, the highest attainable standard of physical and mental health. And Honora is right that these are not set out in terms of stipulated duties, not even implicitly so. And it's not indicated in any way who the corresponding duties are incumbent upon. I think it can still be inferred that the duties in question fall primarily upon the governments concerned. For one thing, again, it's a treaty between governments establishing treaty-based obligations. Sometimes this is clearly so, as in the reporting obligations laid down in Article 16. Sometimes, as I say, it has to be inferred because the political ethos of human rights works against a background where there is a strong sense of state responsibility for the conditions of life in a country. Now, Honora may be dissatisfied with just pointing to state responsibility in this very diffuse way. She may worry that the duty is not being assigned in any more specific way than its general assignment to the government that has responsibility for the right bearer concerned. She may have been looking for the specification of some particular agency or office holder within the government. Or perhaps she thinks that the idea of rights held against the government, rights which impose duties upon governments, is just too easy, and that a rights-based ethic should be less institutional than that. She's right, and if we had an example of a rights-based ethical theory to think about, then we could have debated this. But anyway, even if we're talking about human rights documents, the fact is that assigning the burden of human rights duties to governments has its implications too for the duties of ordinary people. And I think here I disagree a little bit with Laura. Anything done by the government relies on the taxes of ordinary people. It relies on the pressure of the politics of ordinary people. It relies on the willingness of ordinary people to play their part in the processes and enterprises that these rights require. And I think, yes, we all have an obligation to pay attention to Laura's right to be fed. If it becomes apparent that for whatever reason she is not being fed, then we ought to act together, be willing to pay together, and be willing to pressurize our rulers to do something about this. And this is a matter of duty. It's not a matter of just benign generosity. In a world of human rights, one is not a citizen in good standing if one opposes or organizes against the raising of the resources that are needful for the rights whose urgency has been identified. Let me say that again. In a world of human rights, one is not a citizen in good standing if one opposes or organizes against the raising of the resources that are needful for the rights whose urgency has been identified. Human rights impose human duties, and those duties are as diffuse and widespread as the rights themselves. In the final analysis, it is everyone's responsibility to look out for each other's rights. In moral life, generally, many of the duties we have are duties that we have in common with others. That's one of the things that the Universal Declaration lays down in its preamble, when it says, and I quote, "Every individual and every organ of society shall strive by progressive measures, national and international, to secure their universal and effective recognition." That's the universal and effective recognition of these rights and their observance. So the preamble indicates a shared duty that we have to exercise together. The state is the mechanism through which we, as flesh and blood moral individuals, carry out our duties in regard to human rights, and it's the mechanism by which the performance of our duties is coordinated and made effective. I really want to insist on that these rights are supposed to embrace every human being, which partly means that they impose duties on every human being, which we think of as being duties on the part of every human being whose performance must be coordinated and, if need be, enforced by the states that have primary responsibility. Now, as well as duties incumbent on states, citizens, and taxpayers, the charters we're looking at also impose duties of international action. Laura mentioned this when she talked about other entities. In Article 22, for example, which is a provision dealing with general social security, there is talk of the realization of the right through national effort and international cooperation. And also in Article 22 of the Second Covenant, there's talk of international measures likely to contribute to the effective progressive implementation of the present covenant. So we're looking not just for particular states to coordinate the duties of particular individuals, but we're looking for international organizations to play their part in that coordination as well. All of this suggests that we can look to the duties of states, we can look to the duties of sub-state actors, and we can look to the duties of super-state actors in regard to social and economic rights. Now, of course, resources may still be limited, whoever the duty is incumbent upon. And when the resources are not available to the duty bearers, what are we to say? Laura had some observations on this, but I have to disagree with her when she says that any state that lacks the capacity to implement rights cannot be said to be obligated by them on the grounds of ought implies can. If a state can't directly implement, say, a right to healthcare for all its people, it can do so for some, and it can begin the process of changing its priorities so that the resources available for healthcare are increased. And it can seek international aid to this effect. All of these are duties on the state generated by its people's right to healthcare. An immediate shortfall of resources does not justify shrugging off the right on the spurious analytic basis that ought implies can. It will be clear that I feel very strongly about this, about the attempts that are made in modern social philosophy to discredit human rights, particularly social and economic rights. And my sympathies are very strongly with what Stefan said about the whole enterprise. If one is determined to read and look and think carefully, we begin to see that international human rights law does explicitly impose a wide and subtle array of obligations. If, on the other hand, one is determined to reach negative conclusions, if, like Eric Posner, Stephen Hopgood, and Nigel Bigger, and Sir Ian Malcolm, critics mentioned in lecture 1, if one is just out to discredit human rights, then one might try to convince an audience that the topic of duties has been neglected altogether, but that would be a wrong and unfair impression to give, and I'm very pleased that Honora did not venture into that treacherous territory. Now, there's also a more general analytic point here. Sometimes Honora talks about counterpart duties, as though rights and duties were strictly and statically correlative. As she has said in another context, rights must have well-specified counterpart obligations. Other times she hints at a more dynamic picture. She says that the shift in ethical thinking that interests her is a shift that makes rights rather than duties fundamental. It doesn't eliminate duties, but it treats rights as a foundation on which claims of duty are erected. I think the second, more dynamic perspective of one sort of consideration helping to generate another sort of moral consideration is an enormously helpful one. I was brought up in the company of legal philosophers Neil McCormick and Joseph Raz to recognize that the function of rights is to generate duties, not to stand statically correlative to them. The fact that we sometimes have to figure out who in the circumstances should bear the duties associated with a given right is not a flaw of human rights drafting. It's not a flaw of rights-based reasoning. A case can be made that this is exactly how rights are supposed to work. So as Raz puts it, a right of one person is not a duty on another. It is the ground of a duty, a ground which justifies holding that other person to have the duty. One justifies a statement that a person has a right, said Raz, by pointing to an interest of his and to reasons why it is to be taken seriously. And one uses the statement that a right exists to derive, often with the aid of other premises, conclusions about the duties of other people towards the right holder. This is Raz's interest theory, and I do think it's important here. It suggests that rights are prior to duties in the order of argument, in the sense that they mark out interests whose importance is then implicated in arguments that generate conclusions about the existence of duties. It has some interesting consequences for what we've been talking about today. Raz says in his article on the nature of rights, a popular thesis maintains that to every right there is one correlative duty. But he says there's no reason to suppose that we're talking about a one-to-one correlation. Many rights ground duties which fall short of securing their object, and they may ground many duties, not just one. He says there's no closed list of duties which correspond to the rights. A change of circumstances may lead to the creation of new duties. This dynamic aspect of rights, says Raz, their ability to create new duties is fundamental to any understanding of their nature and their function in practical thought. I think one of the things that this is interesting for is in regard to what Honora says about conflicts of rights. Conflicts between rights, she says, quite rightly, are frequent, and it's not clear how they are to be resolved. Again, that treacherous phrase, it's not clear how they are to be resolved. Okay, it may not be clear. What if it's difficult and requires careful thought? That, I think, is the burden of what she said about judgment and interpretation. What would some of the ingredients of that thinking be? Well, the first thing to acknowledge is that when we say rights conflict, what we really mean is that the duties they generate are not compossible. Conflicts of rights are really conflicts of the duties generated by rights. So two people, A and B, may be said to have rights which conflict if some interest of A's is important enough in itself to justify holding some person C to be under a duty, whose performance by C will not be possible if C also has to perform some other duty whose imposition is justified by the importance of some interest of B's. Yeah, so it's the duties that are generated that come into actual conflict. That's where the hard edge of the conflicts occurs. So what we refer to as the trade-off of one right against another need not involve the sacrifice of one of the rights. Rather, it involves a decision not to do or to qualify what is required by a particular duty associated with the right. Remember too, our previous point, that there's no reason to suppose that rights stand in a one-to-one relation to duties. For one right, there may well be many duties. The right not to be tortured generates not only a duty not to torture, but also a duty to investigate allegations of torture, a duty to train security officials to avoid torture, a duty to prosecute torturers, all those many duties set out in the scores of provisions of the Convention Against Torture. One right, many duties. So back to conflicts, it's important to understand that when two rights conflict, this means that one or more of the duties generated by right A is incompatible in the time being with one or more of the duties generated by right B, but seldom will all of the duties generated by right A conflict with all of the duties generated by right B. So this means that even while we are trading off one duty generated by A's right against one duty generated by B's, we may nevertheless be perfectly well able to fulfill other duties owed to A in regard to that right. And that's partly what I was responding to Laura 10 minutes ago when I suggested that even if there's a shortage of resources for some social or economic right, the absence of the resources doesn't just close things down on the grounds of what implies can, because the right in question continues to generate other duties to place constraints on the sort of production and trading decisions we make in the economy, duties whether or not to import luxury goods at the expense of medical resources, duties about how many doctors to train, and so on. All of this is generated. So an individual's right doesn't simply become qualified to call from view once it has been traded off against the rights of others in the sorts of cases that we are imagining. It remains in the picture, and it must be taken seriously as a residual source of other duties and other obligations. There's lots more to be said about this, and I'm conscious of time and I really want to bring this to a close, but let me just add a couple of further points that will be worth considering. First, if conflict of rights is a problem for right-based moralities, then presumably conflicts of duties are a problem for duty-based moralities. If rights have to be qualified, so it is likely do standalone duties have to be qualified. So I don't understand why this is a matter of such special concern in the case of human rights. Is it just that duty theorists have always admitted this, whereas we imagine that theorists of rights, especially human rights, have tried to conceal it? Secondly, if we are comparing a sheer conflict of duties between duties and nothing but duties, duties not based on anything else in a duty-based morality, if we're comparing that with conflict of the duties that are generated in a rights-based morality, then I think it is arguable that we are better off in the latter case than in the conflict of duties generated by rights, because at least in this situation, we can refer back to the underlying interest or concern at stake in the respective rights to see if that evaluative idea is somehow more heavily engaged on the one side or the other. We have something that is supposed to be generating the duties that are in conflict, and maybe we can appeal to that something. This is very sketchy. Maybe we have something to appeal to in the judgment that, as Honora says, has to be made in the circumstances of moral conflict. Those are just a couple of suggestions. And like Laura, I don't have a picture, but I would be very interested to hear what Honora would say. I think as the last commentator, it falls to me also to say on behalf of the panel how pleased I am to have had the opportunity to respond to these considerations, how much I've learned from these lectures, and how much I respect the importance of the enterprise that Honora has undertaken here today. Thank you very much.
Thank you so much, Jeremy Waldron, for these thoughtful comments. Maybe we give Honora a few minutes to collect herself. As you like, Honora.
Up to you.
I think it's up to you. I think you should decide. We can, we can take a little break, because I imagine one needs to collect oneself in light of these rich comments.
Well, as you know, I shall not be making organized comments that pick up all the rich variety of things that you have between you said, which I'm very grateful for.
So would you just like to go ahead?
I'm very happy to go ahead if others are.
Okay, so the screen is yours.
Thank you very much. Yes, I have no desire to oppose right-based and duty-based approaches. I think they march together, and that my worry is only whether, if we focus too narrowly on rights, we fail to see the full breadth of the canvas, because we fail to see the variety of sorts of duties that there are. And in a sense, the bit that was new to me in writing this was the bit about the perfect duties that do not have counterpart rights. Because when I looked at the literature, I found that the striking thing was that quite a lot of people, notably John Stuart Mill, but many others, assume that if it's a perfect duty, it has a counterpart right. And yet, I found it very difficult to see what the counterpart right would be in things like a duty of honesty. Where does the counterpart right sit? It's not, I think, plausible to say I have a right to be told the truth, or a right to, perhaps in particular cases, in particular legally structured cases, I would have a right not to be defrauded, for example. But it seems to me that the problem that we have hit with the shift to prioritizing rights is that we've simply wiped part of the ethical landscape. I do not wish to reinstate that landscape at the expense of human rights. I'm in no way hostile to human rights, but I do want to retain it. I'm greedy, you see. I want to have rights and duties and the lot. So of course I have to have those duties that are clearly correlative of rights. I'm very grateful to Jeremy in particular for reminding us how elaborate the systems of duties can be for what looks like a simple single right, and how you fall back, as it were, if things aren't perfectly in place, on duties to start instituting, to start implementing, to start supporting the relevant right. And that seems to be something rather positive about giving priority to rights. What I'm concerned about is the extraordinary narrowing that we get if we make rights foundational, in that we then appear to set aside a whole lot of perfect duties. And those are that's the thing that I'm most worried about, that the perfect duties recognized for long have somehow, in the course of the last century, very frequently been reconstrued simply as duties that have counterpart rights. So if there isn't a right, isn't a duty. And that seems to me a mistake. I think there are those duties. And I'd like to put that to you all as, in a sense, for me, that was the central issue in trying to get into these problems. Not to query the importance of taking rights seriously, which I don't for a moment, but to see that maybe that couldn't provide us with the complete story of what we want to get a hold on. So I do not have prepared notes, obviously, because I have just met your comments and your criticisms, but that is the area where I am puzzled as to how we can recoup the perfect duties without counterpart rights. They do seem to me very important, and that was why I used the ethics of communication in the second lecture, in order to illustrate how many duties that are commonly taken to be where we say yes, but you can't actually claim them. One of the reasons you can't claim them is that it is very frequently, for example, permissible to be silent. We're talking very often about communication here. If it's permissible to be silent, then as it were, these duties of honesty and accuracy and so on do not generate rights. Now I've, as it were, gone back to my obsession, but I'd be very interested to hear your reactions to my obsession.
So if you like, maybe each of the commentators can respond once, and then we turn to a couple of questions from the audience, if that's okay with you. Who would like to go first and respond to Honora's obsessions? Jeremy.
I think Honora's obsessions are tremendously important. And as I said at the very beginning of the comments, they are something that I applaud, particularly when she focuses on things like civility, honesty, silence. We now hear. I'm a notoriously bad singer, and my father, who was a vicar, used to say, Jeremy is one of those people who can best praise God by remaining silent. But also in my own thinking about hate speech, for example, it's always tempting to think there have to be rights which generate duties against hate speech, rather than thinking that hate speech violates other duties that are shaped much more like the considerations that Honora was talking about, particularly in lecture 2. So I just want to applaud this aspect of the lectures, while remaining, of course, defensive about human rights as an important part of the picture, but part of the picture.
Well, I have no desire to reduce rights. I sometimes think people have, as it were, tried to inflate certain rights in ways that don't work, but that's, so to speak, a try-on. And it's probably in the long run self-correcting, at least if the courts are reasonably robust.
Yeah, so maybe, I don't know, should I?
Sure, go ahead.
Also say my 2 words about Honora's obsession. So I think the obsession is exactly right, specifically the one to do with perfect duties without counterpart rights. So I've also found that in the literature quite a lot, rights for relative duties and perfect duties are being equated to one another. And I've always thought that why should we have 2 concepts in the first place? And I could think of examples a bit along Honora's lines. One of the difficulties that I find in relation, though, to the category of perfect duties without counterpart rights is that even in some of the cases that Honora mentioned, for instance, civility or honesty, I really do wonder whether it's impossible to imagine who the right holders would be. So it's a bit like with promise keeping. We tend to think that promises give rise to moral rights. And so could there not be a right that we all have to be treated civilly? Or could there not be a right that we all have to other people's honesty, at least under certain conditions? I mean, I don't know, but is it really unimaginable? Can we not think of people having the standing to claim, you know, when someone is dishonest with me and say, you're being dishonest, I claim that you be honest with me, in the same way in which I claim that you come and meet me at, I don't know, noon for lunch, or I demand that you treat me civilly. So this is a bit the, you know, how exactly do we draw the line between cases that fall in the perfect duties without counterpart rights versus the ones that have rights? I mean, my favorite cases are special beneficence cases. Someone else brought it up yesterday. But yeah, so this is my obsession prompted by Honora's obsession. Does that make sense?
Thank you, Lara. I see what you're thinking, and I've tried to, as it were, see how could we push the envelope of duties of civility, duties of decency, duties of honesty, because these are the sorts of duties that seem to me to be very important. And the results have always seemed to me to be incomplete. That is to say, of course, if I am negotiating a business transaction with someone, then I have, and it's quite clear, and it will be laid down, duties to declare honestly what it is that I'm putting on the market, and when I will deliver it, and how much I will or won't accept for it. So in particular contexts, we have, of course, a large and detailed legal apparatus that requires aspects of these duties. But these duties are so much more. That is to say, they make their claims, I think, even when people are not engaged in a transaction with one another. They make, of course, we all know that sometimes the claims are difficult and we deal with them by being silent, and we are often not wrong to be silent. That is, as it were, the remedy that people have. But because I agree with you entirely, we can think of examples where these duties have counterpart rights. These tend to be institutionally developed niches, but I think it's quite hard to see them as having counterpart rights in all cases.
Stefan.
Well, if I also may just jump in. So for me, actually, this was also a discovery on Nora. So I hadn't thought about this. So that means that I haven't made up my mind on this topic yet. But thanks for bringing this up. This is really an insight. My hunch actually is that these duties are very broad, if not to say vague. I mean, they border to what often is called virtues. So a certain attitude in a certain way, what that means in a specific situation, and then you come in with all these right concerns about practical judgments is up for grasp. So one has to make a decision here what that actually means, honesty in that situation, or what civility in that situation means, and how far it should go. So in that sense, it's not surprising that we can't come up with specific rights and the right holders on the other thing. That's just the case because the duty is so broad, and that's I'm not sure whether it troubles me that it is bordering to virtues, or whether I think that might be just so the ethical landscape is broader. It's not only duties and rights. Maybe some aspects of virtue ethics come in as well. So whether we have certain attitudes and certain character upbringing that is needed to actually be the right duty bearers and discharge our duties to the right holders. So probably more is needed than just a phrase, this is your duty, but we have to have a certain attitude. And it seems that that is what is covered by virtue ethics, and that also some of the things like civility seems to be, we have to be in a certain, I wouldn't say mood, but we have to be in a certain attitude of civility to actually take the concerns of our co-fellow citizens seriously. If we are not, we would never listen to them. So in that sense, I think that is what is meant. And I think that is very important, actually. I'm not really sure how I would actually place them in the ethical landscape.
Well, the distinction that I was trying to get a grip on is the distinction which you may say falls within virtue ethics, as I don't really use the term virtue ethics, I'm not sure, but the distinction between duties that are discretionary and duties that are not discretionary. And it seems to me that there is a difference that we don't want to lose between, for example, a duty of honesty, where I don't wish to be lying, even in a context where it doesn't matter to the other person, and a duty such as generosity, which is discretionary. And that, it seems to me, is where the two interpretations of the difference between perfect and imperfect duties that I noted draws apart, so that when you get Mill's version, and he says, you know, this terrible, stupid vocabulary, perfect and imperfect duties. It's not nonsense. It is just vollkommene und nicht vollkommene Pflichten. It is complete and incomplete duties. And the distinction is clear enough. But what has happened is that people are trying to extend, if you like, the option of discretion a bit further by not acknowledging that there are any perfect duties that are non-discretionary. And that's what has bothered me in this particular area. And it bothered me much more when I started a few years back to write more on the ethics of communication, because I think communication being, of course, one of the most complicated and diverse of our activities, one discovers as soon as one starts rummaging around that there are very, very many standards that matter for communication, but they aren't standards that others can claim as a matter of right, if only because silence is often permissible. Now, isn't there in the US Constitution, Jeremy, a right to remain silent in certain contexts that I vaguely remember? No, it's a right against self-incrimination, perhaps that which is narrower. But there is a difference between the case where I have no duty and the case where I have a duty but the other person cannot claim it.
Thank you. We're slowly running out of time, but maybe we can take a couple of more questions from the audience. There is Bernhard Jackel. Would you like to pose your question yourself?
So I've just given you the, I've allowed you to unmute yourself, Jakob, so you can ask your question yourself if you want to.
No response?
It
Yes.
goes.
Ah.
No. Yes.
Mm-hmm.
So my question addresses the idea of rights as trumps, but in a more modest version. So couldn't one still see rights as trumps only in the sense that they can function in specific tragic cases like end-of-life decisions and so on as subjective rights, which must be respected by the legislation of a state, because the whole situation should be interpreted only by the acting individual and their idea of some duties and not by the state. Could Professor O'Neill, despite all limitations of rights, agree on such a more modest version of rights as trumps?
I suppose I bridle a little bit because I'm in no way hostile to rights. I think that that is perhaps something I haven't got across properly. I'm not trying to limit rights. I'm just trying to say, as I've said before, I'm greedy. I think we want the rights and then we want some other things too. And what we also want, for example, is certain additional duties that perhaps lack counterpart rights, or Jeremy made a very good case, by the way, for thinking there might be indirect ways of enforcing rights, which the right holder was in no position to claim. But you know, I can be even greedier than that. And I think we should look for ways in which we can see what it would take to respect additional standards, not just those that can be claimed by right holders or on their behalf.
The next question is from Alexa Zelentine. Hi, Alexa. Would you like to pose your question?
Yes, thank you so much. I think my question has probably been answered, but I better double check. So I was inspired by Laura's talk and the question, what are human rights enough for or not enough for?
Yes,
and I think clearly they're not enough to cover all of morality or even all of political morality. But are they enough to protect the fundamental interests that many moral theories see at the foundation of any moral justification of human rights? And I have the impression that they might not be, because these fundamental interests, if I follow you correctly, cannot be protected even if we had a clear understanding of the corresponding duty bearers or corresponding duties, because there are some additional duties that are needed to uphold the entire system that are not really correlative, but nonetheless necessary. I'm putting this very poorly, my apologies.
Well, it's a very large question, but it's a very good question. Thank you for it. Because I think what you've pointed to is the question of, well, what are the duties that, so to speak, support the whole system? On the whole, when one's thinking about counterpart duties, particularly in an institutional context, what one has one's eye on is who ought to do what? Whose role is it to do this, to do that, to do t'other in the institutions? But you're suggesting that it might not add up to enough to cover all the rights claims, are you? Or have I got that wrong? This isn't quite a
yes.
dialogue. Here's Alexa again.
Yes, sorry. Yeah, that's what I meant.
Yeah, well, that seems to me very interesting, because it's, I mean, what Jeremy said, I think provides a good bit of insight into that, what we have is in fact a multiple assignment of duties to many parties, and if the institutions have been well constructed, then the deficiency here might be made up for by activism there, or initiative there, or the rest of it. And one likes to think that that would be how a civilized society would actually work, that shortcomings would be picked up. But one would also be aware that sometimes they might not get picked up, and not every society is in a position where that will happen. Yes, I mean, it gets very complicated at this point, doesn't it? Because we're contemplating a world in which the duties are distributed across a lot of parties, and the claims of right holders are pretty complicated to formulate, to enforce, and to respect, because the counterpart duties are highly diverse, highly distributed, and that all gets difficult. Not impossible. And with a well-working society and a superb legal system, we can just imagine that this might work.
Okay, so the last question.
I do think complexity is one of our problems in all this, and as it were, being not myself a lawyer, I'm all too aware how complexity can take over in discussion of human rights. But on the whole, I better complexity than oversimplification.
Thank you. The next and last question we can take is from Michelle Mason-Bisri. So she asks me to read it out. So the question is the following: does one have a right to honesty or the truth? Or alternatively, is the right that of not being deceived? If the latter, then the problem of the option of another remaining silent is silent. I can demand of any other generic other person that they do not deceive me, even if I cannot demand of them the truth.
Well, we certainly have no right to be told the truth. The people with whom we're dealing quite often do not know the truth. So they cannot be responsible for asserting only what is true. They can be responsible for example, not misleading or not poisoning the wells, for not circulating disinformation or propaganda. There are all sorts of, I think, informational duties that do make reasonably good sense, but they seem to me generally to fall quite short of a duty to provide the truth to another person. You're right that the right not to be deceived is often something that can be tied down, particularly in quite simple contexts. And it is tied down in law. For example, in if I order something online and what turns up is something completely different, much less valuable or indeed horrible, then I can go to all the trouble and return it and get my money back, and so on. But that sort of redress is not there for every case in which I'm misled. And that's why it seems to me that these duties that bear on communication are so immensely important and interesting and extremely difficult to tease out. Of course, what we often do is to look at the cases where they have been most worked out in most detail in law, for example, precisely in matters of trade and retailing and the like. But not all of life is like that.
I'm afraid we are at the end of our time. So thank you so much, Professor O'Neill, for this inspiring series of lectures on why human rights are not enough. I would also like to express my gratitude again to our distinguished commentators, Stefan Gosepat, Laura Valentini, and Jeremy Waldron, for their engaging and thought-provoking comments. I think despite the pandemic-related circumstances, which did not allow us to meet in person, and I'm very sorry for this, I think you all managed, given these circumstances, to make this a really lively and memorable event. Thank you so much. We all hope to be able to invite you to come to Munich in person before long. Thanks also to our audience for attending and for raising interesting questions. And last but not least, I'd like to thank Marius Baumann, Corbinian Rüger, Lea Württemberger, and Petra Weishaar for their invaluable help in putting this together, especially given the technical intricacies of this event. So thank you so much for all your help. It would not have been possible without you. I hope to see you all in 2 years from now when we hold our third Munich Lectures in Ethics, and Professor Susan Wolf already agreed to deliver them. So thank you so much again, and have a very nice evening.
Thank you, Monica.
Monica, thank you very much.
Thank you.